We will now proceed to consideration of Resolution 107D. The Chair recognizes Professor Salzberg of the District of Columbia, Delegate of the Criminal Justice Section, to move Resolution 107D. Professor Salzberg.
Thank you, Madam Chair. I move adoption of 107D.
Second.
So, ladies and gentlemen of the House, 8.5 years ago, we began work on the fourth edition of the criminal justice standards on the prosecution function and the defense function. No one thought it would take the better part of a decade. We have been blessed by the work of Professor Rory Little of the University of California at Hastings, who's here in the hall, for all the work he did. It was an heroic effort, and I hope we can thank him. Our task force was chaired by Federal District Judge, then Chief Judge, Jack Tunheim from Minnesota. By the time this process dragged on, he thought he would finish his term as chief and become senior, which may have happened. Why did it take so long, and why is it so important? I believe that most of us in the criminal justice section think this set of standards is the most important thing we've ever brought before the House. It addresses what prosecutors do every day and what criminal defense lawyers do every day. And for the first time, we drafted and debated the two sets of standards simultaneously. In the past, we would do one, get it approved, then do the other. And we thought this was an important part of the process for two reasons. We wanted both sides to be able to argue for essentially equality of treatment in certain areas, and two, to argue for differential treatment in other areas where they thought it was appropriate. And we wanted to have it debated fully, completely, to the point where we hoped, when all was said and done, we would get a consensus, and we did. Remarkably, the prosecutors in the criminal justice section, 201, support the defense standards, and vice versa. The defense lawyers support the prosecution standards, and it's an awesome product. We have been blessed, by the way. As some of you will recall, Neil Sonnet and I withdrew the standards at the August meeting. And we did that because a number of different bodies in the association and elsewhere said that even though it was late in the game, they thought that there could be improvements. So we had a meeting in Washington, and widely represented. IR&R was there, SCLAID was there, NLADA was there. I'm not going to tell you what all these acronyms mean. You know most of them, and if you don't, it's not really that important. NAD, National District Attorneys Association was there. Our Standing Committee on Professional Responsibility participated, and we had a meeting in which everybody got heard, and at the end of that meeting, everybody was satisfied in principle that we had improved the product, that we took care of every problem that anyone had raised, and then after we agreed in principle, it was up to Professor Little to make sure that he could reduce what was in principle to what we could put in words, and no one would think that we cheated. And he did that, and we did it, and what we are bringing before you is a product that is a consensus of all of those groups. Some people ask, could you give us a red line comparing the fourth edition with the third? And the answer was, no, we couldn't, because there were so many changes. We actually started, long ago, we started with a proposition that we rejected in the end. The proposition was, if we saw something that we didn't think was that great, but it wasn't awful, we would leave it, because it didn't do any harm. And over time, we said no. If we're going to do these standards, we want it to be the best, which is one reason we were willing to step back again in August. We said, our belief about this association is it functions best when we don't rush forward and ram something through because we think we can. It's when we step back, let everybody participate, let everybody rally behind a product, and then come forward and say, this is the best we can do. And I will tell you, this fourth edition is the best we can do. It is the best we have done. It is something that everybody who's been part of it will come before you and say, I am proud to have been part of this effort. Now, one thing I should tell you is the commentary to this that explains everything that's in it has not yet been written. And that is out of respect for the House. No one wanted to write a commentary and ask Professor Little to put in the time until we were sure that as we came before you today, there were no last-minute catches, no last-minute glitches, that what we were putting before you is something that I could say in introducing this is our best effort. And when we put the commentary together, we will go and give those organizations, again, a chance to be fully heard so that that commentary matches what we regard as the gold standard of the black letter that we are asking you to approve. It is with great pride that the Criminal Justice Section, the Standards Committee, and I hope every one of those organizations, and I may have missed a couple, because Science and Technology weighed in at various points on this, but the great help we had in doing this represented the commitment to excellence, not just on this House, commitment of excellence of all of those organizations that care so much about American criminal justice, that want it to be the best in the world, that want it to be a model, that want these standards to be what we've proclaimed that they have been from the outset. They are what former Chief Justice Berger said. They are the finest product with respect to criminal justice that the world has seen. And in that sense, and with that pride, I ask you to vote enthusiastically for Resolution 107D.
Thank you, Professor Salzberg. The chair is holding no salmon slips in opposition to 107D. Mr. Weeks. The chair recognizes Bob Weeks of California, delegate from the Santa Clara Bar Association, to speak in favor of 107D.
Good morning, fellow delegates. I'm Bob Weeks from San Jose, California. I was a career public defender for nearly 30 years, served a term on SCLADE, and which led the charge Professor Salzberg has mentioned last fall. He is correct. Since then, there was a meeting, everybody's on board, and we greatly appreciate their willingness to hear, as he said, even at the 11th hour. I just want to say a word or two about what this means to the indigent defense community. Last Saturday, we had our annual Indigent Defense Summit, and these rules, their predecessors, were among the things most cited, particularly the rules of defense counsel, the duties of defense counsel, even where there's a plea. Now, I spent some time in my career working in a busy plea and settlement calendar, and occasionally the judge would be in, "Why aren't you going faster, Mr. Weeks" mode. After I got enough gravitas in the local bar, I could say, "Thank you, Your Honor, I'm going as fast as justice will allow." How much better, now I can say, which we have Rule 46.1 says, before you plead a client, you're supposed to conduct appropriate investigation and study of the matter, and that should include discussion with the client and an analysis of relevant law, the prosecution's evidence, and potential dispositions and relevant collateral consequences. So now I could have the presence of mind to say, "Thank you, Your Honor. I'm doing my best to comply with my ethical obligations under Standard 4.-6.1b of the ABA Standards for the Defense." Please join me and Professor Salzberg and all the others who contributed to this effort and pass this resolution. Thank you.
Thank you, Mr. Weeks. The chair recognizes Neil Sonnet of Florida. Mr. Sonnet waves. Professor Salzberg, you have the right to close. Professor Salzberg waves. We'll proceed to a vote on 107D. All those in favor of adopting 107D, please say aye. All opposed, no. The ayes have it. Resolution 107D is adopted.